It's time for our story number 2 of the day. We are going to the Supreme Court, so who else would we have but our expert here, Katie Barlow. The question tonight is, should the Supreme Court adopt a code of ethics? And pressure is mounting, despite the justices not being able to reach an agreement here. And here to break it all down, our chief legal correspondent, Katie Barlow. I imagine a lot of this has to do with the drama that has been surrounding Justice Clarence Thomas lately.
A little bit. That's some of it. There are some calls for maybe some more transparency for Justice Thomas and his wife, given her push after the 2020 election to overturn the results. But it's not just about Clarence Thomas. In fact, a number of the justices have at different times kind of forgotten to include things in their financial disclosures or their regular disclosures that they make every year. And so this is part of a bigger conversation about what's required. And here's the thing. The United States Supreme Court justices are not bound by a code of conduct that all other federal members of the judiciary are. All other judges are bound by a code of conduct. The 9 are not. Now, part of that is, well, who can make them abide by those rules, right? They're the head of a co-equal branch of government. Congress can't really tell them what to do, and who's going to enforce it? Let's say there is a problem with a particular justice, then what? I mean, who's going to enforce it against them? So there are a lot of thorny legal issues to sort out here, but the one thing that Congress can do, as you know, Congress holds the purse strings, right?
Oh, yeah.
So they could tie funding for the Supreme Court. Every year, the Supreme Court has to get funding from Congress. They could tie funding to certain conditions, like, hey, guys, put a code of ethics out there. We want to make sure that happens, so we're going to tie your funding to creating that code of ethics. We also know from reporting from the Washington Post and the New York Times that the justices have considered it, but they haven't reached agreement on it. Imagine that.
Well, you know, I think that this time around, it seems like this court is very split, and it's been politicized, some would say, and maybe this is why this conversation is coming back up. But you're an attorney. They're attorneys, at least at first, right? They took the bar. There was an affirmation oath that they took, akin to maybe the Hippocratic oath, if you will, for doctors. Does that not stand? Is that not enough? And what exactly, I mean, if there is another, say, ethical oath that they may take or a code of conduct, I mean, truly, it's not a legal codification that would implicate them in any sort of criminal activity, if you will.
It's a really good point, the oath that they take. And in fact, the justices say themselves, look, we abide by the same rules that the other federal judges abide by. We just aren't bound in the same way that they are. But they make financial disclosures, and they recuse themselves from cases when they are involved financially or a spouse is involved financially to some extent. But here's the thing. Nobody can make them recuse from a case, and it's ultimately up to them. So we're back to that enforcement problem. But they do.
We saw Ketanji Brown Jackson, sorry to interrupt you, she accused herself. I think it's hard because you've been in this large government, if you will, for so many years. You know so many people. There's always going to be a conflict of interest. Do we know, is there anything similar for Congress members? Because there's been questions about them. And also, like you say, there's co-equal branches. What about for the executive?
Yeah, I mean, politicians are subject to the voters, so they get, you know, every 2, 4, 6 years, they have to go before the voters and reconvince them, hey, you got to put me back in office. Part of the problem with justices is a lifetime appointment, and so there's nothing that can really make them do anything once they get on the bench. But yeah, congressmen, senators, they're required to make financial disclosures, and the public is aware of all of those things that are happening. They're not supposed to be, you know, knowing inside information and then benefiting from it financially after passing laws. So
we can always say that works, but
it's not always. But then, hey, the Justice Department gets involved, and there's a balance of powers there. There's some prosecutions. And the world goes round and round.
Oh, boy, this is so complicated, but here we are, Katie. Do we know when this could happen, if it does?
Well, the justices themselves are talking about it, but it doesn't seem like there's any agreement anytime soon. There has been a bill proposed in the last week, and the senators are looking at it, including Virginia Senator Mark Warner, who's part of one of the co-sponsors of the bill in the Senate, that would enforce this code of conduct on them, including some more transparency in their disclosures. But again, you got to get both sides of Congress to agree.
Good luck.
And that's as difficult as getting 9-0 on the court. So we'll see how that goes.
All right, Katie, keep us posted.
Thanks.